Houston Maritime Attorneys. We serve injured maritime workers nationwide. Offices in Texas and Louisiana. Just like any other industry, seamen are at risk of suffering work-related injuries any time they are on the clock. The courts recognize this and are continually working to protect injured seamen through general maritime law. Maritime law gives workers who have been injured offshore or in the maritime industry the chance to claim necessary compensation for any suffering of medical complications. The following acts are foundational to maritime law: Jones Act, Death on the High Seas Act, Limitation of Liability Act, Longshoremen and Harbor Workers Compensation Act. General maritime law is the basis for all injuries sustained by seamen. It is important to have a comprehensive understanding of the general law before delving into the subsequent acts. How to choose the right maritime injury attorney. Maritime law can be complex. Although these laws are designed to protect the rights of maritime workers who become injured or ill, they can be difficult to navigate. This is why it's crucial to seek legal representation from an attorney who has a deep background in this area of the law. It is essential to select an experienced maritime lawyer. When choosing an attorney, you should inquire about the number of maritime cases they have tried. Don't allow an attorney to dance around your questions. You need to select someone who is prepared to give honest, direct answers to all of your inquiries. The basics of maritime law. Maritime law is derived from many sources, including federal statutes and general maritime law. These sources provide some of the maritime doctrines that are commonly used in cases involving vessels and their passengers and crew. Maritime law sets forth many of the basic legal tenets associated with the sea and seamen, including seaman's right to maintenance and cure. Maintenance and cure refer to the benefits a seaman is entitled to until she recovers and is fit for duty. However, there is a maximum medical improvement limit that can control the amount of compensation received. Maintenance includes such expenses as the seaman's rent or mortgage, utilities, property taxes, homeowners insurance, and food. Cure is similar to workers' compensation benefits for employees. It covers costs related to medical treatment for the work-related injury. A seaman is someone who is a captain or crew member aboard a vessel in navigation. Also similar to workers' compensation, maintenance and cure does not require that the seaman prove any fault for their injury. The employer is required to pay. The Jones Act. The Jones Act is a federal law that gives seamen a statutory right to sue their employer for personal injury damages. However, a seaman must spend at least 30% of their time working on a vessel to qualify for the Jones Act. Not only does the Jones Act provide the seamen a statutory right to sue their employer, it also eases the burden of proof needed to prove causation between the employer's negligence and the seaman's injury. Under the Jones Act, the employer's negligence only needs to play a part in the seaman's injury rather than being a proximate cause. The Jones Act also incorporates aspects of the Federal Employment Liability Act. In particular, claims filed in state court under the Jones Act are not removable to federal court. The Death on the High Seas Act. When the death of an individual is caused by a wrongful act or neglect occurring on the high seas, the DOHSA guarantees that a personal representative of the decedent can bring a claim. The Saving to Suitors Clause. Federal law establishes exclusive jurisdiction for admiralty and maritime cases in the federal district courts absent any language indicating the contrary within a statutorily created right, such as the Jones Act. However, the Saving to Suitors clause reserves any non-admiralty remedies that m. History of Admiralty and Maritime Law. Maritime law, also referred to as admiralty law, is nearly as old as the shipping industry itself and governs most accidents that occur on navigable waters. The law's roots can be traced back to the unwritten customs of nautical behavior of the Egyptians and Greeks. However, the earliest formal codes were established around 900 BC on the Greek island of Rhodes. The original maritime laws and codes stemmed from the ancient customs and rules of shipping. For example, the doctrine of general average, the concept that all sea cargo stakeholders, owner, shipper, etc., evenly share any damage or losses that may occur as a result of a voluntary sacrifice of part of the vessel or cargo to save the whole, can be traced back to the early shipping customs of the Rhodians. The concept of a separate legal authority regulating maritime issues was brought to the West by Eleanor of Aquitaine, who learned of the concept when she accompanied her first husband King Louis VII of France to the Mediterranean on the Second Crusade. The term Admiralty law came from the British Admiralty courts, who presided over maritime matters separately from England's common law courts. As the U.S. judicial system is based on the British system, amended Admiralty laws were gradually incorporated into our legal system soon after the Constitution was ratified.